As part of our special series commemorating 75 years in the Supreme Court, Advocate Gulnar Mistry writes about whether public interest litigation or PILs still serve the public. Public interest litigation started in the late 1970s. A PIL allows a third party to bring forth issues faced by marginalised individuals or groups to the Supreme Court. When it came to PILs, the rules of locus standi, or the right to file a petition in the Supreme Court, were relaxed. This encouraged public-spirited parties to move the court on behalf of those who could not. Eshna Benegal was the first PIL to be taken up by the court. Several prisoners awaiting trial were released after the court was informed about their prolonged incarceration. SP Gupta vs. Union of India outlined important boundaries for the relaxation of locus standi. In its judgment, the Supreme Court sounded a word of caution. One must be careful to see that the member of the public approaching the court is acting in good faith and not personal gain. Phase 1 of PIL jurisprudence focused on petitions on the rights of marginalised communities, while Phase 2 dealt with environmental causes brought by individual petitioners and civil rights organizations. The court heartily welcomed such petitions, which highlighted causes that affected the public at large. It was the turn of the century that ushered a rather confusing phase for public interest litigation. In 2001, while dismissing a persistent public litigant, the Supreme Court stated that public interest litigation is now trending as a publicity of private interest litigation. However, 3 years later, the court considered a challenge to the imposition of interest tax that held that a private interest case can also be treated as a public interest case if it consisted of wider unresolved problems. In another puzzling move, in 2006, the Supreme Court seemed to revert to a narrow approach. It described PIL as a weapon to be used with great care and circumspection. They declared that any petition that seemed mischievous in nature would incite ruthless repercussions, like in 2010 when a weak argument resulted in heavy penal costs. However, despite the threats and lengthy guidelines, weeding out motivated PILs is far from what actually happened. For example, consider the petition that brought about the order to play the national anthem in cinema halls across the country. Or how in matters concerning migrant workers during the pandemic, directions were announced without giving a proper chance to the workers to have their say. All this begs the question. Public interest litigation, yes, but who is the public? All this and more in Gulnar Mistry's thought-provoking article. Read it now on seobserver.in.